SJC-13531, Commonwealth v. Maryann, Russo.
Okay, Attorney Cusick, whenever you're ready.
Good morning, Your Honors. May it please the Court, Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth is asking this Court to vacate the allowance of the motion to dismiss and restore this animal cruelty case to the trial list. In this case, the motion judge had before him the detailed record of application for complaint, and it contained ample probable cause to charge this defendant with animal cruelty. The motion judge dismissed the case, finding that the cruelty statute did not have an affirmative duty to euthanize a pet that was loved and cared for, and I suggest that that was an incorrect standard to apply and went far beyond what was necessary to establish probable cause.
As I look at the statute, what I'm stuck on is the word willfully and how we're going to interpret that, because I think it's significant, because sometimes we say willfully means intentionally by design, not accident, and then sometimes we say willfully means you have to intend the harmful consequences. I know we've said the first one in the arson cases, but I'm not, most of the time we say there's a harmful consequence.
Your Honor, I would suggest that in this case, with either definition, we would get to willful here, in that the record before the motion judge showed ample evidence that this dog was suffering and that the defendant was aware of it and was not taking any steps to alleviate or any palliative care or anything to prevent the dog from suffering further.
Where did they get the pain medication?
Your Honor, that is not in the record before the application for complaint. Again, that's something that I suggest, if this were to go to trial, would be established at a trial, when the Commonwealth would have an opportunity to bring in additional evidence as to where that may have came from, who prescribed it, when it was obtained by the defendant. So I suggest that at the probable cause phase, the fact that the pain medication was present in the house and that there was a representation that the dog wasn't being given the medication because, according to the mother, the dog didn't need it, coupled with the other statement, again, where when the officer mentioned concerns about the animal's suffering and said it was obvious, rather than address anything like that, the family made comments about don't include that and don't mention that.
So as we track the statute, we have the owner of the animal knowingly, and there's no dispute, willfully intend the harmful consequences, authorized or permitted the dog to be subjected to, and you're saying that the intended the harmful consequences, that being of unnecessary suffering?
Not exactly, Your Honor. I mean,
Okay.
here clearly the defendant knowingly and willfully, I would suggest, her actions were knowing and willfully. She knew what she was doing, she knew what the results would be, and proceeded with this course of conduct.
Well, she has to, as you said, if we look at the second part of willfully for intend the harmful consequences, because we don't have torture or cruelty per se, we have unnecessary suffering. Where's the evidence that she intended the unnecessary suffering of the animal?
Your Honor, I suggest that could come from her actions,
But,
again, at the probable cause.
Let me first ask you, under your reading of the statute, that's your burden to prove, correct? At least on probable cause.
We would have to satisfy all of the elements
Okay.
on probable cause. We would have to provide some evidence to meet all of the elements.
Okay,
I agree with that.
including intend unnecessary suffering. So again, where's the probable cause of that finding, for that finding?
I would suggest here the probable cause could be found from the fact that the defendant, again, at the animal hospital, took the animal out of the animal hospital against medical advice, And then when, and represented she was going to bring the dog to another veterinarian. Upon learning that the special officer was investigating the case, left a voicemail that I suggest a reasonable inference is that it was false about the dog having recovered. And looking at that, I suggest that that shows she was aware of what the dog was experiencing, and again, for her own reasons, did not wish to alleviate the dog's pain. And I would suggest that that's something that could be found to be willful.
What do we do with a record showing that there was nothing to be done to alleviate the dog's pain?
Well, Your Honor, we have, the veterinarian said that the dog was super painful and nothing could be done, but also we have the evidence that the defendant removed the dog from the animal hospital against medical advice, and...
Yeah, I mean, you're not saying that the dog had to be euthanized.
No, that is not the Commonwealth's argument.
Yeah, the Commonwealth's argument, I thought, was that related to the pain that this dog was suffering.
Yes.
But I'm wondering how the vet's statement that the pain cannot be controlled is consistent with the defendant intending unnecessary suffering if it can't be controlled.
Your Honor, I would suggest where we're at the probable cause stage,
Yeah.
we would have more evidence at trial. But I know one of the amicus briefs, I think, mentioned the Kliegler decision, and there's a talk of palliative sedation. Maybe the dog could have been sedated such that the dog was not feeling pain. Again, that's something that could potentially...
But the record shows just the opposite. It's not like the record doesn't say anything. I thought the record was that the pain could not be controlled.
And that was one veterinarian's opinion or statement in there, and again, the defendant then removed the animal from the hospital. She wasn't prevented from doing that. She didn't bring the dog to another veterinarian for care there.
But the vet didn't also give her pain medicine, right? The vet says, we want you to euthanize her, but the vet doesn't say, here's pain medicine while you go see this other vet. The dog needs pain medicine because she says the dog's in super pain, right?
Yes, Your Honor, that is what the veterinarian says.
And then she lets her leave. I'm not saying she shouldn't have let her leave, but she also doesn't offer her any medicine, right, according to this record.
According to this record, Your Honor, but I suggest we don't have the medical records from this visit and from the visit on December 25th.
Well,
We're
but
not...
some vet gave her pain meds.
Yes, Your Honor, that they did have possession of pain medication. That is in this record. And again, where that pain medication came from is something that I suspect will be established at a trial. And I suggest here there's several questions raised in some of the briefs about, well, the officer didn't do this or ask this or where'd this come from. I suggest that, again, that the answer to those questions were not necessary to develop probable cause to charge animal cruelty in this case.
Sorry, speaking of probable cause more broadly, could you address whether you think there was probable cause here on the record before us if we accept the following reading of the statute, which is a little similar to some of what the appeals court said, that the statute criminalizes, quote, knowingly and willfully authorizing or permitting actions subjecting an animal to unnecessary torture, cruelty, or suffering. I'm playing with the words a little bit, as you will well know, because you must know the statute backward and forwards. But it's not just the existence of pain from natural causes. It's that the person authorizes or permits subjecting, and I'm putting in brackets around subjecting an animal. And I think that one could mount an argument that that is a fairly natural reading of the statute, given that all of the rest of the items in the statute are just terrible things that people are doing to animals. There a whole listing of awful forms of cruelty that people cannot do to animals. And then essentially the final provision is, and you cannot willfully or knowingly authorize and permit subjecting an animal to cruelty and suffering. So I think the appeals court addressed it through the lens of ambiguity or something, but I think it might also be read as just naturally saying, you can't do all these terrible, cruel things, and you can't willfully and knowingly authorize someone else to do those things. So I know you don't want to, but could you accept that, accept that reading of the statute where the the animal has to be subjected in some way by a human to suffering as opposed to just natural causes, would you say that there's still probable cause here under that reading of a statute, and if so, why?
Your Honor, I would suggest that the action by a person or something like that, that this language encompasses that, but is not limited to that. And I suggest that that's the plain reading of the statute. And I don't know if I'm answering your question, because I think I disagree with the premise.
Well, but I'm asking you to embrace the premise for a minute, and because your brief explains very clearly the other, not the premise, but under the premise, because I don't, there obviously is an omission here.
Sorry, no what?
There's an omission here, right? So she did not do various things for this animal that it is contended amounted to inflicting pain and suffering on the animal. So are you contending that, do you think that there's probable cause, even under the reading of the statute that I laid out, that you do not want to accept on the basis of a sort of omission theory?
Your Honor, I would think here, if the court is saying there has to be an actor, some other person.
Someone subjecting the animal to cruelty.
And again, I disagree with the premise, but again, here there's no, the record before the motion judge didn't suggest there was some other person.
Well, there's the mother and the other person living in the house. Arguably, she's authorizing or permitting them to allow the suffering, right? I mean, you could, there are, I mean, you're relying on the conduct of the mother and somebody else to prove the defendant's misconduct in this case. I'm not sure that's appropriate, but that's what you're doing in part. So there is some authorizing and permitting going on.
Well, Your Honor, I would suggest,
Help you here, so better.
thank you, Your Honor. Here, I think the evidence is that the defendant was not in the house, that she'd gone to work and had left the dog in the care of other family members.
So is she permitting her family members to allow the animal to suffer unnecessarily?
Your Honor, I think that might be a stretch to say that that's
a stretch. You've got some problems with Justice Stewart's question then, because those are the only people she's, again, accepting her framework. Those are the only people who are doing that, right?
Well, Your Honor, I suggest that the defendant is the person identified as the dog's owner and the person who is identified as making the shot.
But Justice Stewart's framing this as, this looks like, the words used, because there's a legislative history saying this authorized and permits was used to expand the statute in other contexts, right? Because they don't want owners off the hook by subcontract, giving their horse to somebody who then mistreats it. So there is some issue with that authorizing and permitting language being added to deal with third parties, correct?
Yes, Your Honor. So perhaps, again, under that reading where, again, I'm not accepting the premise, but if that is the premise, then yes, I accept that you could say that the family members were the actors in this situation. I would accept
I
that.
ask you to address a different question, which is, or a slightly different question. When the statute requires an owner to affirmatively provide care, shelter, food, it specifically says the owner who doesn't do these things, which is not palliative care. It specifically says food, drink, shelter, sanitary environment, or protection from the weather. Those things are punishable as animal cruelty when the owner fails to provide those. But there is no similar act of omission with the final paragraph under which the Commonwealth seeks to proceed. Usually, in statutory construction, the statement of one thing in one paragraph indicates not the thing in the other. And I'm wondering what the Commonwealth's response is to that.
The Commonwealth's response to that is it's a separate part of the statute. It's got separate language with the knowing and willful that doesn't apply to the other aspects about the food and the shelter and all of that. So it's got a more heightened mental state required. And then when you get to suffering, again, that's something that can happen in...
This is, I board my dog at the horrible dog daycare, and I know that they mistreat the animal. That's, I think, the scenario that we're
I think it would
talking about.
encompass that, Your Honor, but I think it also encompasses what happened here, what was alleged in the application for complaint here.
Counsel, I don't want to lose you before getting an answer to Justice Dewar's question, because I have the same issue, but I'm going to make it a little bit more focused. Can you construe this language to say that you are, by omission, you can subject someone to? By omission, not by doing something affirmative, that you're subjecting an animal to this by doing nothing. Can you meet that statutory definition in saying that you're subjecting an animal to a naturally occurring condition by doing nothing?
Your Honor, I suggest here we can, because while death is inevitable for all living creatures, suffering and pain is not. And so I suggest here that this animal had a prolonged, painful suffering that the defendant knowingly and willfully authorized and permitted the animal to be subjected to by not taking any...
But what's significant, though, when the pure neglect, when it's laid out in the statute, is described as food, shelter, et cetera, not the deprivation of medical care, which is really what happened here, correct?
Well, Your Honor, I see one could argue it that way, that it's a deprivation of medical care, or that it's permitting the suffering to continue for a prolonged amount of time.
But then the problem is, under the statute, the unnecessary suffering, which I think this animal endured, unfortunately, that comes in the subjected to portion of the statute, not the earlier portion of the statute.
Correct.
Okay, thank you.
Thank you very much.
Attorney Bolio.
Morning. May it please the court, I represent Maryann Russo. Ms. Russo is present in the audience this morning. I believe this case presents a difficult factual scenario. It certainly did to Ms. Russo when she was confronted with this with her sick dog.
The statute entails natural causes, right? Natural suffering.
I'm not sure it delineates anything, whether it's natural or unnatural.
Right, so if my dog steps in a hole and breaks its leg, right, so it's not a deprivation of food, water, shelter, and I don't take my dog to the vet, have I caused unnecessary suffering?
I'm not sure under the statute. I mean, I certainly, my personal choice would be I would take my dog.
That's not criminal?
I would take my dog to the vet. I think in that situation, I think it would matter what caused the dog to
So if
suffer.
I'm completely indifferent, I say, he's having a bad day, that's not cruel and that's not unnecessary suffering? That's not criminalized?
So I guess it could be if you were aware that your animal had a broken leg and you allowed the animal to languish at home with a broken leg and did nothing to treat it.
Wouldn't that certainly satisfy knowing? I don't know if it satisfies willful, but it certainly would. If the dog steps in a hole and breaks its leg and is howling nonstop and in pain, which dogs do,
Yes.
you know that dog's suffering, and you're knowingly allowing that dog to be subjected to suffering. I don't know if you're willfully doing it, because that's a whole another question, but you're certainly knowingly allowing that dog to suffer if that's the case, right?
I certainly think that argument could be made.
I mean,
I agree with you,
Let's
Ron.
go further. Not that it's just an argument, right? That's knowingly allowing your dog to suffer, isn't it?
Yes.
Okay. So how is that different? Again, let's leave willful aside. How is that different when you know your dog is in terrible pain at this stage of this illness?
There was
Now, she takes the dog to the vet. I get that. But if she hadn't taken the dog to the vet, that would be knowingly allowing the dog to continue to suffer too, wouldn't it? To be subject.
I'm not sure that it would.
Really? Why not?
It was because it's not an unnecessary, he's not suffering unnecessarily, he's dying a natural death.
Well, but
Well, the vet clearly gave a different alternative that would ease end the dog's suffering, correct?
Absolutely.
And we have your client at least deceiving the vet on 2 occasions, correct?
I'm sorry, you're on
Being
deceit.
deceptive.
I would suggest no.
Well, viewed in the light most favorable to the Commonwealth.
the light
Of
most
course, you
favorable-
wouldn't suggest that, but yes.
Viewed in the light most favorable to the Commonwealth. I believe the evidence suggests that my client presented the animal to the vet twice within 3 weeks, once on Christmas Day, another, I believe it was January 12th. This was an emergency veterinary hospital. I don't think that my client was doing anything to secret.
Well, she said that I'm going to take the dog to be euthanized to another vet. That
For-
wasn't true, right?
For a second opinion. I'm going to take the dog for a second opinion.
To be euthanized.
I believe it's for a second
But
opinion.
either, and we're just talking about probable cause.
Yes,
I
Your
mean,
Honor,
these
we are.
seem to be trial issues.
Yes, Your Honor.
It does, and that Justice Gaziano, Justice Wendland's point is the thing that I would like to focus on, because this is in the light most favorable to the Commonwealth.
It is.
So for probable cause, I'm still wondering how the motion judge could allow a motion to dismiss with the factual, at least the alleged factual chronology here of going in December, saying, have the surgery, I'm not going to have the surgery, come back a few weeks later, the dog now has deteriorated and say, now I want the surgery, and the vet says, I'm not going to do the surgery, the dog won't survive. You've got all of these indications that this dog is in absolute distress in the application for the complaint. And then you have the stuff about, I'm going to go to another vet, I'm not going to go to another vet, they don't go to another vet. We've got all of this stuff in the application underlying the complaint. And in the light most favorable to the Commonwealth, how is this dismissed?
I mean, I would suggest in the light most favorable to the Commonwealth that the statute doesn't call for involuntary euthanasia.
Well,
that she didn't commit
we
any.
we can leave aside the euthanasia part.
Yes, sir.
About just the part about also getting treatment. Again, so even though there might be the language from the vet about there's nothing really further I can do, the issue about whether that's really true in the light most favorable to the Commonwealth, there is indication in the underlying documents that that they got something for this dog. Okay. Right? That was in the stuff that underlied the application, right?
Excuse me, Your Honor?
That somewhere along the lines there was some medication, some sort of treatment that
I believe the application suggests that my client noticed a mass on the side of her dog on Christmas Day. She thought that it was uncomfortable, and she presented the dog based upon that. The application doesn't contain evidence of this, but
don't you lose unless willfully means that because there's no, I understand how you win this motion to dismiss if she is required to intend the suffering, because there's no indication in this record that she wants this dog to suffer, I don't think.
yes, Your Honor.
But if that's not what the statute requires, probable cause is certainly here, for all the reasons that Justice George has just pointed out. But don't you need us to interpret willful to mean that she has to intend the suffering? And that's what this statute requires.
I'm not sure.
but the statute to justice, it says subjected to unnecessary.
Yes.
Okay.
Willfully subjecting the animal to unnecessary suffering. It's not just that she subjected the dog to unnecessary suffering, or at least suffering.
Respectfully, I'm not sure that she did.
The dog is in terrible pain. She's told by the vet that the dog is in super pain, right? And she doesn't want to euthanize the dog, nor does she leave with pain medicine.
She wasn't prescribed any pain medication, and she wasn't given any supplemental oxygen, with all due respect, Judge.
But if she knows the dog's in super pain, and the vet is telling her to euthanize. I understand she doesn't have to euthanize, but doesn't she have to address the pain?
At that point, because the vet said, I'm not sure that she knew that there was anything that could be done to control the pain, because the vet said the only thing that can be done to control the pain is euthanasia.
No, that may be, but again, this is in the light most favorable to the Commonwealth, and this is a probable cause.
Understood. In the light most favorable to the Commonwealth, I would suggest the physical condition of the animal in the condition in which the animal was found would suggest that there's no evidence of abuse, that everything was being done to provide palliative care.
Come on, please. There's no evidence that this was the right way of dealing with this dog?
I'm not saying that it's the right way of dealing with the dog, and I'm not saying that if it was my dog that I may have put the dog to sleep, but what I'm suggesting is that there's no evidence that she intentionally and actively abused this animal. She loved the animal.
There's no intent, there's no evidence possibly that she intended the suffering.
Yes.
I get that she wants the dog to live and she doesn't want the dog to suffer, but the dog is suffering, then that's different.
In terms of and I understand Your Honor's point. It's well taken. With regards to the dog suffering, there was nothing that could be done to control that suffering.
Well, that seems like a trial issue, right? I mean, on that, you probably lose. Isn't your best argument that nobody other than natural causes is subjecting the dog to that suffering?
Yes, it is, Your Honor.
Okay.
It is my best argument.
Even if there's evidence in the application that there is something that could have been done,
If there's something that could, I'm sorry, Your Honor?
that there's something that Ms. Russo could have done, short of euthanasia. Because the chronology is, you can have surgery,
Yes.
and she says, I don't want the surgery. And then 3 weeks later, comes back and says, I want the surgery now.
Yes.
And the vet says, I'm not going to do the surgery now. So again, this is in the underlying support for the complaint. And in the light most favorable to the Commonwealth, drawing all reasonable inferences
Yes, Your Honor.
in their favor. That this doesn't get over probable cause?
I don't think that it does,
Okay.
because there's no evidence of any sort of suffering that my client subjected the animal to. She was in a no-win situation, a situation that I think all of us that are blessed to own pets are faced with.
By the way, just that formulation you just said, there's no evidence that the dog was subjected to suffering.
Yes.
But the dog is, the absence of medical care or the absence of medicine or painkillers is subjecting that dog to, that dog is suffering, right? I mean, I don't know if she's willfully doing that, but the dog is suffering. I find the appeals court subjected to, I don't know what that means. What does that mean?
I would suggest caused, or permitted or allowed to be caused.
Well, subjected to, the appeals court says is passive. So it's just they're requiring it not be medical. I don't know.
I would suggest, Your Honor, that when faced with this situation, there was nothing else, that she could have done. She was giving the dog palliative care. The dog was in a clean diaper.
Don't we need to believe that's a factual? I understand that the mother or the brother says, here are the pain meds, right? When they go to the house, right? Do we know if isn't that a factual issue, whether that's true or not?
Whether those were in fact pain medications?
Whether they're telling the truth, whether that's, even if there were pain medicine, were they giving that to the dog? Was it in any way help? Is it recognized pain medicine that a vet would consider palliative care as opposed to who knows what this stuff is? We don't know anything about it, right?
Right. And I would suggest that there was no investigation that was conducted by the Commonwealth. The investigator didn't ask who prescribed these pills, whether or not they saw a veterinarian, anything of the like. I would say that is certainly relevant to this, but there's no evidence to suggest that the dog wasn't being given pain medication. There's some statements of my client's elderly mother, she's in her mid-80s, that said the dog, I believe that the dog doesn't need these pain pills anymore, but I think you can take that for what it's worth. That doesn't mean that my client hasn't been giving the dog pain medication for 3 weeks, or that the dog hasn't been cared for. I would suggest that the evidence suggests the otherwise, that the dog was loved, the dog was cared for, they were providing palliative care, they were trying to keep the animal healthy, or strike that comfortable in its dying days, and I would suggest that there's no probable cause to believe she violated the statute. And if there's no
Can
other
I ask you
questions-
to address the legislative history a bit? Because it seems like the prior version of this same statute said something to the effect of if an owner knowingly and willfully authorizes or permits the dog to be subjected to or to suffer unnecessary torture or cruelty. That language was changed to the current version. How does that affect our analysis about whether or not this new third paragraph requires affirmative actions by the owner to prevent pain in a dog?
That subjecting to, I'm sorry. I
Yeah,
don't
it used to
understand
be, the statute used to say to be subjected to or to suffer. And no longer says that.
Yes.
Now it just says to be subjected to suffering.
Yes.
Is there anything about that change that affects our analysis?
Well, I would just cite the appeals court's reasoning that the appeals court wrote that the passive construction.
But it used to have both. It used to have the passive construction and also allowing and permitting to suffer.
Yes, Your Honor. I would stand behind that, the appeals court's evaluation of it. They wrote that the passive construction stands in stark contrast to the active construction, as to the active voice of the other verbs in the statute. And it goes on to write, unlike those verbs, subjected to identifies no actor, and there must be one. So I would suggest to the court that the appeals court's reading of the statute, that there must be an actor that's subjected to the animal to the harm at issue. I believe that would be relevant to this court's determination.
But the way that's the problem that I have, is that's giving a nexus to the action, but it says unnecessary
Yes.
suffering. So it's not necessarily that there's an actor that causes it, but back to the original question from Justice Dewar, by omission, can't you violate the statute, or at least for probable cause, by doing nothing and allowing whatever suffering you didn't cause to unnecessarily be prolonged? Can't you do that under this framework?
I would say that you can't. Not with an animal that's dying a natural life, not with an animal whose condition that you played no part in causing. I would say that you can't. If there are no other questions, I'll rest on my brief. Thank you very much.